Valuing intellectual property, or IP valuation. IP valuation is an important function for all businesses. It helps them to secure financial investment. It helps them to identify walkaway position in negotiations where IP is involved. It is the foundation to establish damages in infringement cases. For instance, we'll be looking at the US yardstick, what is called the Georgia Pacific factors, on how to determine reasonable royalties. And reasonable royalties can also be determined even without there being an infringement suit. Say the parties go in for arbitration and the arbitrator has to determine the royalties. So IP valuation could again be relevant in those cases. And it could be relevant for legal and accounting reasons. Now, there are some challenges in valuing IP. There is a level of subjectivity and you need to make some assumptions with regard to intellectual property rights. And some scholars have called it probabilistic rights, that the rights may exist now, but there is no certainty that they will exist in the future. And there is a lack of information to identify the benchmarks. This comes out of the intangible nature of IP. And obviously there is a shortage of valuation experts because IP is an interdisciplinary field, and having people who are steeped in the knowledge of valuation and in the knowledge of IP could be difficult to find. For startups, the challenge is in defending the valuation during a negotiation, because startups, the value is always in the future, so it becomes hard to value the IP when it is in its early growth phase. Now let's look at some of the valuation methods that are there in the market. A fair value approach is commonly followed. The valuation is to reflect the reasonable assumptions and estimates made by the business. And there are significant factors to be considered: information about the business, understanding of the market conditions, marketability of the final product of this or the IP based on the IP, marketability of the final product or service based on IP, and to see to what extent it contributes to the product. IP at times may be a small contributor to the value of the product. And the two major approaches of valuation are the cost-based valuation and the market-based valuation. Now we look at these two approaches in detail. The basis of a cost-based valuation is the economic principles of substitution and price. Are there any alternatives to the product, and what could be the price the market wants to pay? The value of the IP is assumed based on the historical production and protection cost, and the information required for this approach involves material cost, isolated costing of tangible assets used in the development of IP. We had seen this in R&D. It could be the laboratory, the equipment, the salaries. There's quite a lot of tangible assets that go into creation of IP. We need to look at the labor cost, wages, fees, compensation, insurance, etc. Apportioned overhead cost, redevelopment information, profit and incentive component. Now the application of cost-based valuation happens for new IP, for exchangeable, for intangibles like software, where you can use a different code for doing the same function. The royalty rates are determined as a fair rate of return based on the cost of IP, and an estimate of internal return of investment of IP, of associated technology or other intangible asset. Some common issues with cost-based valuation: there is no correlation between sunk costs and real market value of IP. We had mentioned this in the instance of Microsoft software. The sunk cost may not reflect the market value of the IP, especially for software which has become outdated. It does not account for economic and market factors relating to IP. Opportunity costs are not considered. Risk associated with economic and other returns are not factored. Technological obsolescence is not factored. Like for instance, software which could have cost millions to develop may not be relevant after some time. Now, the market-based valuation, which is the other approach, the basis is the potential of economic returns to be earned from products and services using IP. The two market-based valuation approaches are comparable transactions or industry benchmarked approaches. There is a comparable transaction in the market, so you use that as a guideline, or future income based approaches. What could be the future income that the IP can bring? Now, this approach is used for benchmarking similar technologies or deals with IP at similar stage. It is relevant when the market information on prices, royalty rates, or investment is available. Then it's the most reliable method. If information on comparative transaction is available in the market, then this works well. However, it depends on access to information such as product life cycles in industry, potential barriers to entry, and potential for income growth. Now, the issues with the comparable approach is that you have to be identifying similar IP, and finding similar IP could be difficult. It is very hard to find another intellectual property right which has gone through the same cycle, same growth phases, and which can be equated for comparing value. Difficulty in obtaining details about terms and conditions of relevant transactions. Most of the time there are confidentiality clauses covering these agreements and they are not available in the public domain. Market may sometimes undervalue the IP at an early stage, especially for startups, due to information asymmetry. The other approach is the future income approach. The future income approach, the basis is forecasting income streams expected from IP and discounting it in present terms. So, income is regarded as cash flow and not profit. Identifying potential income is the foundation of determining future income. Assessing the duration of the said income, risk assessment of forecasted income. The information required includes selling price, market share, volume or number of product, capital expenditure, time for regulatory approval, historical prices of sales, cost, profits, etc. The future income approach, like the comparable products approach, has certain issues. Identifying the appropriate income stream sometimes becomes a problem. Obtaining various information that is required is again problematic. Forecasting future income streams can be risky. And issues with discontinuing rate, what rate to choose, could be another issue. Now, what method would a person choose? The cost-based method is used for legal and accounting requirement standards requires you to use that. Taxation, capital gains tax, stamp duty liabilities all go by a cost-based method. The market-based method is used in determining license and royalty fees. That's one of the approaches. And to get financial investments into a firm, and for strategic reasons to identify the worth of a business. When there is a wholesale takeover of the business or valuation of the business, this is being used. In an infringement suit, the courts would use especially the courts in the US, the United States would use what is called the Georgia-Pacific factors. In India, we have not evolved any specific yardstick for the courts to determine royalty. So we use the approach in other countries. So this is a set of factors which looks at royalties patentee receives for licensing the patent in suit, the rates licensee pays for use of other comparable to the patent in suit. So there is also, it factors the comparative approach, comparable product approach. Nature and scope of license in terms of exclusivity and territory. Licensors established policy and marketing program to maintain patent monopoly by not licensing others to use the invention. Commercial relationship between licensor and licensee, such as whether they are competitors or inventor and promoter. Effect of selling the patented specialty in promoting sales of other products of the licensee, the existing value of the invention to the licensor as a generator of sales, and the extent of such derived or convoyed sales. The court will also look into the duration of patent and terms of license, the established profitability of products made under the patent, commercial success, the utility and advantages of patent property over old modes and devices, the nature of the patented invention, the character of the commercial embodiment, the extent to which the infringer has made use of the invention, and the value of such use. In infringement cases, the extent of use is also factored. The portion of profit or selling price customarily allowed for the use of the invention. If there is some past instances, that will be factored. The portion of realizable profit attributable to the invention as distinguished from non-patented elements. So the court will do an analysis of the contribution of the patented elements to the value. Opinion testimony of qualified experts like the people who value IP valuers, say accountants and experts in the field, their testimony can be factored in. Outcome from hypothetical arm's length negotiation at the time the infringement began. So the court will envisage a situation where the licensor and the licensee could have entered into an agreement before the infringement began.